Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross LLC. Imagine that you just signed a huge contract. You've been working on the deal for months and it looks like a big win for your company. Unfortunately, the contract contains a tiny overlooked mistake that's going to cost your business a lot of time, stress, and possibly a lawsuit. As a practicing small business attorney, I've seen lots of deals go bad and end up costing businesses hundreds of thousands of dollars. And usually it's over a small overlooked detail in the contract that ends up causing confusion, misunderstanding, and disputes among both parties to the contract. In this video, I'm going to walk you through the 10 most common contractual mistakes. And for each one, I'll break down the mistake, why it's so harmful, and exactly what you can do to protect yourself and your business. And to date myself, we're going to do this David Letterman top 10 list style, although probably not as funny, but we'll see. By the end of this video, you won't just be able to spot these mistakes, but you'll be able to know how to fix them before they happen. And please, if you like this video, please hit the like button and ring the bell in order to get notified when future videos drop. So let's get to it. Mistake number 10, not having a written contract. This is the most basic mistake of all, and I've already talked about it in my legal myths video. However, it absolutely needs to be reiterated. You absolutely cannot rely on a verbal agreement. In some instances, verbal agreements are completely unenforceable because of something called the statute of frauds, which invalidates many types of oral agreements like contracts over real estate or contracts that can't be completed within 1 year. But even if a verbal agreement is enforceable, you don't want to rely on it because it's hard to enforce because the details are hard to prove. Think about it. You and your partner agree on a project. At the time, you were both excited about it and you both thought it was clear what everyone was agreeing to. 6 months later, however, your memories on key details have gotten fuzzy. He swears you said you'd cover all the marketing costs. You know for a fact, however, that he agreed to a 50-50 split. Suddenly you're trapped in a he said, she said battle, or he said battle, depending on who your partner is, with no way to prove who is right or wrong. This has nothing to do with distrust. It's just a fact that people's memories are unreliable and people often have drastically different memories about an event or a conversation. Relying on verbal agreements is just asking for confusion, missed deadlines, and bitter fights over money that are unenforceable. The fix for this mistake is easy. Always put an agreement in writing. I don't care if it's a small project with a freelancer or $1 million acquisition. It should always be in writing and should include key terms in order to prevent misunderstandings and so that you can enforce the agreement if needed. Mistake number 9, using generic internet templates or ChatGPT generated contracts without an attorney's review. I've also talked about this one before in the 5 common myths video, but it needs to be reiterated. You cannot rely on contracts that are downloaded from the internet or are generated by ChatGPT without having an attorney review it. The internet and ChatGPT are fantastic tools, and you can almost find or generate anything you want, but they can't be trusted. They don't know anything about your specific industry, the details of your deal, or most importantly, the laws in your state or country. You could be using a template written for Florida law while you're operating in Massachusetts, and this might make key parts of your contract totally unenforceable. These documents are often filled with confusing jargon or are missing the exact protections you need, like clauses about who owns the intellectual property or what exactly should be kept confidential. Now you might be thinking, I can fix these issues with ChatGPT or some other generative AI source. I can just tell it exactly what I need, what state I'm in, what are the terms of the deal, and so on and so forth. And it's true, you can do that. As I mentioned, it's a great tool and very helpful. But the problem is ChatGPT or whatever other generative AI tool you use is often wrong, and it's confidently wrong. I'm sure you've had the experience where the generative AI tool tells you it's working on something even though it has no capability to do the task that it claims it's doing. And it's even worse with the law. There are multiple cases now of attorneys who have been reprimanded by a court for including legal citations or legal principles in a brief or in a motion that don't exist or are not actually true. Don't let this be you. The solution isn't to never use a free online template or ChatGPT, but to treat anything you find or create by generative AI as a rough draft and not as a final product. Every contract needs to be customized for your business and the deal that you're doing. Spend the money for a legal review so that a lawyer who knows your business, the law, and the transaction can spot any legal issues and tailor the free contract to your needs. This small investment can save you from a catastrophic loss later and a whole lot of stress and heartache. Mistake number 8, using vague or ambiguous language. One thing that will kill a contract and cause all sorts of problems in the future is ambiguity or vagueness. Using phrases that sound legal and professional, such as quote, best efforts, or quote, a reasonable time, or quote, services will be provided in a timely manner, are legal mush terms. They offer nothing concrete or definitive and can be interpreted in multiple different ways. Imagine your contract says a developer will use, quote, reasonable efforts to finish your app. To you, reasonable means working at least 40 hours a week on it so you can hit the critical launch date for your app. To the contractor, it might mean spending a few hours a day on it while they work on other bigger clients that need to be taken care of. Both interpretations are defensible, but will cause all sorts of problems when your app is not ready by the launch date and the date has to be pushed back. The contract's fuzzy language makes it difficult to enforce because without more information, it's not clear that the developer breached the contract. The solution is to be as specific as possible. Vagueness and ambiguity die when you add concrete and specific details. Don't say, quote, in a timely manner, say, quote, within 14 business days. Don't say, quote, best efforts, but instead spell out the exact performance metrics and standards that the other party needs to meet in order to be in compliance with the agreement. Use crystal clear language that everyone understands so there's no room for debate. Mistake number 7, failing to clearly define deliverables and timelines. This mistake is closely related to using vague and ambiguous language, but it's so common and damaging that it gets its own spot on the list. Suppose, for example, you sign a contract for a, quote, new website design. What does that actually mean? Is it 5 pages? 50 pages? Does the quoted price include e-commerce features? Are revisions included? And who's providing the images and writing for the website? And when exactly is the launch day? All of these questions and more should be answered in the contract. If your contract with a vendor does not have a specific breakdown of services, products, and deadlines, you're just asking for trouble. The other party could easily deliver something that technically fits the promised services, but it's completely useless to you. That leads to endless disputes over what was promised and whether you should pay for a job you feel wasn't done right in the first place. To solve this problem, every contract should strive to have a detailed scope of work. This can be done specifically in the agreement, or it can be contained in a detailed estimate that's incorporated into the agreement, or in some other fashion, such as by attaching it as an exhibit. It doesn't really matter, but the information has to be somewhere in the contract. The scope of work section in a contract should include, at a bare minimum, exactly what is being delivered, when is it being delivered, who is responsible for what tasks, and the specific steps that must be finished for the project to be considered complete. This information should be presented in a way that is sufficiently clear and with enough detail so you know when something has been done. This will prevent any disputes in the future about whether certain tasks have been completed and whether payment is owed. Mistake number 6, overlooking critical boilerplate provisions. There are many sections in a contract with very scary sounding legal phrases, like indemnification, quote, force majeure, quote, limitation of liability, and all sorts of other ones. A lot of people skip right over these terms and think it's boilerplate legal fluff that's unimportant. This is a big mistake. These clauses should not be ignored because they are essential clauses that shift risks and potential liabilities between the parties to a contract. They also control where a lawsuit can be brought if there's a breach and possibly what types of damages can be recovered. That indemnification clause, it dictates which party has to pay the legal bills in the event that either party gets sued by a third party in connection with the contract. The force majeure clause, it dictates whether there's a breach of the contract if either party fails to perform because of unexpected catastrophic event, like a pandemic, a hurricane, a war, or things like that. That limitation of liabilities clause, it caps the damages that can be recovered by either party in the event of a contract breach, and usually excludes recovery of certain types of damages like consequential damages and lost profits. The solution to this mistake is to treat each and every single clause in the contract like it's important to the agreement, because it is. Read and understand the boilerplate. If you have no idea what indemnify and hold harmless means, you have to find out before you sign anything. These clauses can shift enormous risk onto your shoulders without you even knowing it. Negotiating these clauses and customizing them can be one of the best things you do to protect your business. Mistake number 5, not recording all terms in the final document. During contractual negotiations, a lot of great ideas are usually thrown about between the parties. You'll have discussions over breakfast, promises will be made over the phone, and the other side will agree to little changes by text or email. But then you often get the final contract and none of these verbal or email discussions are actually in it. This is a classic recipe for disaster. Why? Because most contracts include something called a merger or an integration clause, which says that the written contract is the entire agreement between both sides, and that any other conversations, emails, or promises are irrelevant. Were you promised a 10% discount if you pay an invoice early? If it's not in the final written contract, it legally never happened. The solution here is simple. If a term from the negotiation is important to you, make sure it's included in the final written contract. Do not rely on oral assurances that the other party will follow through on those promises, even though it's not included in the final contract. Before you sign it, do one last check and make sure that every single promise, change, and detail that was agreed upon is written down in that document. In the end, that written agreement is the only thing that a court will care about if there's a dispute. Mistake number 4, ignoring choice of law and choice of forum. A contract should have a statement about what state law governs the contract and what court or forum a lawsuit can be brought in. Sometimes the forum is arbitration in a particular location and with a particular service, but it's the same idea. The contract dictates where any lawsuit can be brought and what state law governs. Many people ignore these clauses because they think that the rules are the same in every single state. But that's simply not true. A rule that's perfectly legal and easy to enforce in one state might be unenforceable in another. For example, non-compete agreements are generally enforceable in many states, but they are almost completely unenforceable under California law. So if California law applies to your non-compete agreement and you're required to bring a lawsuit in California, you're pretty much out of luck if you want to enforce your non-compete agreement. Now, although this is a drastic example, each state has different laws and requirements, and you want to make sure that your contract complies with the laws of the state that applies to the contract. Generally speaking, courts will follow the choice of law provision in a contract. So if your contract says that Massachusetts law applies, you need to make sure that it's consistent with Massachusetts law and can be enforced under Massachusetts law. If it doesn't, you're out of luck. This is another one of those areas where you want to speak with an attorney in the applicable jurisdiction to make sure that your contract complies with the law in that area. With respect to choice of forum provisions, courts will also generally enforce those as well. So you want to make sure that the forum stated in a contract for filing a lawsuit is acceptable to you. If the forum is not acceptable, you need to negotiate a different forum with the other party. Sometimes this can be a bone of contention between the two parties, because for convenience, each party wants the forum to be their home state. If this happens, simply choose a different state for the forum that's slightly inconvenient for both parties. Often, Delaware and New York are chosen for those purposes. Mistake number 3, not correctly identifying the parties. This one seems almost laughable, but it happens all the time, and it can completely invalidate a contract. The contract must have the full correct legal names of the people or companies involved. So suppose, for example, that you are working with an independent contractor who's providing consulting services to your business. Are you working with John Smith, the individual person who's providing consulting services, or are you actually doing business with his company, Smith Innovations LLC? The difference is huge. If you sign a contract with John Smith personally, but his business is an LLC, you might not be getting access to all the business assets or resources. And if John breaches the contract, you might not be able to sue the business for breach of contracts, even though they have deeper pockets. On the flip side, if you want to work with a company, you need to make sure that the person who is signing the contract on behalf of the company actually has the authority to do so. Otherwise, the company can claim that they are not bound by the agreement and you won't be able to sue them. The solution here is to verify everything. Always confirm the full legal name of the business or person you are signing with. For a company, get the register name, including the Inc. or the LLC or whatever they're called. Don't just go by the DBA name. Get the actual legal name of the company who is signing the contract. And with respect to the person signing the agreement, make sure that the person signing the contract is an authorized signatory acting on behalf of the company who has the power to bind the company. A simple mistake here can make the whole contract worthless and cause all sorts of problems for you in the long run. Mistake number 2. Signing without fully understanding. This one should hopefully be self-evident. Signing a contract you don't fully understand is like walking through a minefield with a blindfold on. You could be agreeing to terrible payment terms, giving away your intellectual property under certain circumstances, or inadvertently taking on the risk of a massive liability. Remember that the other side's lawyer wrote that contract to protect their interests and not yours. Often, you feel pressure to read a contract quickly and sign off on it, even if you don't understand all of the terms. The solution is to give yourself permission to pause and don't feel embarrassed about the need to do so. Don't sign a contract when you feel pressured to sign, but take the time you need to read each and every single word. If there's any term or sentence that you don't understand, ask for clarification. And if you're still unsure about the explanation, please get a lawyer to review it with you. The cost of a few hours of an attorney's time is nothing compared to the cost of a bad deal. Mistake number 1, failing to proofread. We've made failure to proofread the number 1 mistake, and you may feel disappointed because it seems like the most boring one of them all. But simple typos and errors are completely destructive. A misplaced comma, a wrong date, an extra zero on a payment amount, any of these tiny mistakes can have huge consequences. A typo in the payment section could mean you're on the hook for $100,000 instead of $10,000. An incorrect deadline could mean you'll be in breach of the contract before you even really had a chance to start on the project. In court, judges often interpret a contract based on what it says, and that means a simple clerical error can commit you to unwelcome consequences. No one wants to go to court and incur legal expenses to fight a battle over a mistake that could have been caught and corrected by proofreading the contract. The solution is to be diligent and proofread the final contract from start to finish. Read the contract out loud so that your brain processes it and thinks about it. Then have someone else on your team familiar with the deal proofread it again and make sure that nothing was missed. And if you can, have your lawyer give it one last pass. This simple final proofreading step is what can save you from an embarrassing and expensive mistake that could have easily been prevented. If you find this video helpful, please do me a favor and hit the like and subscribe button. We put out new content every week to give business owners like you the insights you need to thrive. So let's recap. We've seen that the worst contract mistakes are usually just simple oversights, like failing to get it in writing, grabbing a generic template online or creating one with ChatGPT, using vague language, not proofreading the final document, and other similar things. All of these can be easily fixed, and by doing so, you can turn a contract from a potential landmine into a strong asset that can protect your business. Thank you so much for watching, and I'll see you in the next one.